Welcome to Stream of Conscience, brought to you by Democracy for America, Fairfield County, where we believe that change is possible and you can make it happen. I'm your host, John Hartwell. Our guest today is Connecticut Attorney General George Jepsen, a Phi Beta Kappa graduate from Dartmouth, and with a law degree from Harvard and a master's in public policy from the Kennedy School, George began his legal career as general counsel for the Carpenters Union Local in Norwalk. He was elected to the State House from Stamford in 1987 and to the Senate in 1990, where he rose to the position of Majority Leader. In 2002, he ran as Lieutenant Governor on the Democratic ticket with Bill Curry, and after that election, served for 2 years as Democratic Party Chairman. George was elected Attorney General in 2010 to succeed Richard Blumenthal, and for the past year, he's been deeply involved with attorneys general across the country in negotiating on behalf of homeowners who've been victimized in the foreclosure process. Those negotiations resulted in a $25 billion settlement with the 5 largest mortgage servicers that was announced on February 9th. George, welcome to Stream of Conscience.
Great to be here.
So you're in the job that you really love. And the first thing that was on your plate was a foreclosure agreement with the major servicers in the country. Tell us how that came about.
It was a long time coming. First of all, I do tremendously enjoy the job. I see why Dick Blumenthal stayed in it for 20 years, because every day you get up and have the opportunity to go out and make a measurable impact, a positive impact on people's lives as a consumer advocate and protecting the broad public interest. I feel strongly that the economy and jobs is the number one issue in America, and I don't think that we're going to have an economic recovery or a strong one until there's a floor underneath the housing market.
I think you're absolutely right.
A housing recovery is essential, and the wave of foreclosures that's occurred has helped depress housing prices. It affects all of us, every homeowner, everyone with a 401k. It's not just people who had tough times and lost their homes in the last 5 or 6 years, or those who are currently behind on their payments. Again, this issue affects all of us. One of the an opportunity arose when the large mortgage servicers, the 5 national banks, specifically Bank of America, JP Morgan, Wells Fargo, Citibank, and Ally, they service about 65% of the mortgages in America, and they failed utterly in the period following the financial crisis in 2008 to ramp up for the clearly foreseeable wave of foreclosures that were coming. The result was that homeowners were treated horribly. The foreclosure process is cruel in any circumstances, but they made it a lot worse with their failure to service the foreclosures appropriately. Specifically, there's the so-called robo-signings, false affidavits where they were attesting to the court facts that they did not know whether they were true or not. It's certainly true that virtually all my offices investigated this. Virtually all of those who were foreclosed on were in fact behind on their payments, and it was a legal foreclosure, but the rights of individuals were trampled in the process. Dick Blumenthal, shortly before he left office, joined with certain other attorneys general around the country to initiate discussions with the major mortgage servicers that in effect said, unless you settle these claims, we're going to sue you. So Connecticut was actively involved from the get-go. I committed staff resources when I came into the office. I said, this is my number one priority. We committed staff resources, and I was invited to join. I was on the executive committee for the negotiations and asked to join the negotiating committee this past summer. So I've been deeply and very heavily involved. The settlement has 2 broad pieces. The piece that gets less attention, but which is just as important as the financial piece, is a new set of servicing standards. This is something that no federal agency has been able to produce. The U.S. Congress has failed to produce. But what it is a monitor selected by the attorneys general will oversee banks, and they've agreed to certain critical reforms in the mortgage servicing process going forward. Things like a single point of contact. No longer will a homeowner have to submit and resubmit the same documentation time and again because the files are being lost. So that the bank has to have a single point of contact to case manage each homeowner's file. Secondly is what we call no dual track. It has been the case that banks, while they were negotiating a loan modification with the homeowner, is simultaneously pursuing a foreclosure. That's just not fair. Under the new rules, a bank will have to exhaust the loan modification process before they can initiate a foreclosure, and any move to foreclosure that has to be reviewed by an independent monitor. More staff, more bilingual staff, and so it's our hope. Clearly, a lot of people are still going to lose their homes in foreclosure, but it will not be until alternatives have been exhausted, and B, they will be treated more fairly in that process. What's gotten more attention than the servicing standards is the $25 billion pot of money that the banks have committed. The money will be allocated in 4 different ways. Firstly, the most important piece of it is about $17 billion will be available for principal reduction. The typical case would be a homeowner who was a true victim of the financial crisis. They were making their mortgage payments on time. They weren't subprime. They were playing by the rules. They're victims. They lost their job, fell behind on their mortgage payments, eventually found work, but maybe not at the same level of compensation that they enjoyed before. And so if they could get that loan reduced, say, from $200,000 to $150,000, they'd be able to stay in their home. So about $17 billion for loan modifications, of which about $120 million would be available here in Connecticut. The second biggest piece is refinancing. There are a lot of homeowners out there who are current on their mortgage, sometimes desperately, taking 2 jobs, but they can't get refinancing to take advantage of today's historic low rates because their mortgage is underwater, their home is underwater. And so under this program, about $35 million would come to Connecticut for refinancing of these loans. If these 2 pieces of the program are implemented properly, it will be an important first step in Connecticut to putting a floor under the housing market while bringing measurable relief to thousands of Connecticut homeowners. Not everybody's going to qualify. Your mortgage has to be owned by one of the 5 large mortgage servicers, for example. Mm-hmm. So not everybody's going to qualify, but it will bring relief to several thousand people here in Connecticut.
So you said that these servicers are servicing 65% or so of the mortgages nationwide. Is that roughly the same here in Connecticut?
It's pretty close to that in Connecticut. There's some regional disparities. Wells Fargo is a little bit more out on the West Coast. Citi is a little bit more in Fairfield County, for example, but those are rough numbers. We've also, now that we've reached agreement with the Big 5, we're already engaged in discussions with the next 9 largest servicers. They have much smaller percentages of the market, 1 or 2% typically, but taken as a whole, if we can reach a similar agreement, and we're confident that we will, that will bring about 85% of the market into this kind of agreement, and the next 9 would bring about another $5 billion on top of the 25 that we have committed so far.
You said at the very beginning that the approach to the banks was, come negotiate with us or we're going to sue you. What were the possible suits at that point, and what did you guys give up in the negotiating process that made this an attractive deal for the banks?
We actually gave up very little, and I'll talk about that. The legal theory, a lot of people have been hurt by this national catastrophe. Everybody has suffered in one way or another. As a lawyer, and so it's a about $700 billion of lost equity. As a lawyer and as a law enforcement official, I can't go after merely bad behavior or greedy behavior or stupid behavior. I'm limited to what the law gives me jurisdiction to enforce. And for example, we have very limited jurisdiction over national banks, but one area where we do have, we had a credible case was the illegal servicing of the foreclosures through those so-called robo-signings and false affidavits. It's a very narrow slice of jurisdiction, but working with federal partners at the Housing and Urban Development and Department of Justice, the banks faced liability at the federal end and potential liability at the state end. And what makes this a good deal, though, is if we had been successful in bringing legal actions, we would be limited under Connecticut law to about $5,000 in fines or penalties per claim. In other words, every foreclosed house where there was a robo-signing or a false affidavit, if we won the maximum, it would be about $5,000 per incident. There have been 7,500 foreclosures in Connecticut with those banks during the relevant time period. So that would have, if we litigated these cases, we would have got only about $35 million, and about 5 years from now, not one penny for homeowners, not one penny of relief for those who need a loan modification. Why'd the banks do it? Because several reasons. One, with federal action, there would be additional fines significant fines to the federal government. Secondly, they need finality. They need to be able to say to the markets, our exposure is limited to X. And finally, through belated and I think kind of self-interestedly, they finally came around to understanding that they are better off taking a haircut on a loan, reducing the principal from, as I mentioned earlier, say 200 to 150, but having the homeowner stay in the home, continue to make mortgage payments, than they are in letting yet another home go to foreclosure, at which point the homeowner stops making payments altogether, stops doing repairs. They may even loot the house of things of value, leaving the bank with something that's worth cents on the dollar.
Right.
So a combination of they understood that weren't going away, the significant liability between federal and state claims, and belated understanding of their own self-interest. What we gave up was, and this is a legal settlement, and so for the claims that we would have been able to bring on the robo-signings and the false affidavits, we gave them releases. We can't go and sue them about that stuff right now. That's the principal release we gave up, but that's what a lawsuit is about. You get something, you give something.
Now, you've given that up at the state level.
At the state level.
Is the individual homeowner still allowed to go to court and,
yes.
and contest
yes.
on that particular?
If you were wrongly foreclosed on, the bank took your home and they didn't have the legal right to do it, you are still free to go to court, and you're free to join a class action to that effect. All we gave up was the state. And when a bank improperly services a mortgage and in effect testifies that the homeowner is behind in payments or notarizes something that they had no right to notarize, even if it's true, but when they do the false affidavit, they're not lying to the homeowner as a legal matter, they're lying to the court. And that's why any fines don't go to the homeowners, the fines go to the court.
But does, in a situation like that where the servicer has falsely claimed that they have certain permissions from the whoever owns the underlying mortgage, or have done robo-signings rather than having a real human being do things like that, does that in fact invalidate the foreclosure?
No. This office took that issue to court, in about 13 or 14 times, if I recall. And courts consistently, 100%, ruled that the fact that there's a false affidavit, if the underlying information is correct, it does not invalidate the foreclosure. And so that's
so what's the point of having the affidavit process if it's not, if you're not going to be held to that standard?
Well, you can still that would subject to you. It breaks the law, but it breaks the law with respect to the relationship with the court. And so that's what
the underlying settlement.
Yeah, it's illegal.
Yeah.
It's just that it's illegal with respect to the relationship of the servicer to the court, and that's why the fine is leveled against the provided to the state.
In doing my research for this program, I came across a report that was recently released out of California where a company had gone in and done an analysis of several hundred loans, several hundred foreclosures, and they'd found that 98% of them had some kind of impairment one way or the other in the process of bringing that foreclosure to.
And that was the strength of our case.
Yeah.
We, working with our federal partners, we investigated loans, a huge number of loans from all 5 of the mortgage servicers, and we were able to show conclusively that the illegal activity, again, the robo-signings, the false affidavits, was systematic. It was virtually every foreclosure involved some kind of illegal activity, and that's one of the reasons the banks realized that they needed to sell it. That if this went to court, first of all, it'd be hideously embarrassing, and when you go to court, who knows what is going to be said in testimony, and so they were wise to sell it, even at the stiff price that they did.
What is an individual homeowner? What should their role be at this point, given this settlement?
Well, if you think you might qualify for a loan modification or refinance, you can come to my website. Go to the Connecticut Attorney General, Google Connecticut Attorney General, come to my website, and the 1-800 numbers for the loan servicers are there available, and so you should make contact. I know already thousands of people have done that, but contact your bank. The banks are ramping up to do this. And people say, why? How can you count on them to do this?
Precisely,
well, there are
yeah.
very stiff penalties if they don't. If they don't hit their target numbers in principal reduction, and each bank has a different market share. How much of the 17 billion in principal reduction that they have to hit collectively. The formula is the percentage of the market that they have is 25% of the formula, and the number of homeowners in arrears is 75% of the formula. So each bank has been given a target that they have to hit over the next 3 years. They have to hit 3/4 of that target in the first 2 years. If they fail to reach their individual target, for every dollar that they fail to make in a loan modification, which isn't writing a check by them, that's they're in effect foregoing
They're adjusting their books.
But they're foregoing income
Yeah.
down the road. It's a real cost
Yeah.
to them because in income foregone, but it's not the same as writing a check. But for every dollar they fail to reach in loan modifications, they have to write a check for $1.40. So it's a real penalty.
There's a 40% penalty.
Yes, and well, again in hard dollars, which is much more aggressive than making the loan.
And who is monitoring this?
The selection was by the state attorneys general. So he's someone we are very confident in. He is currently his name is Joseph Smith. He's the banking commissioner in North Carolina. North Carolina is, of course, where so many banks are headquarters, and he's known as a very strong pro-consumer advocate. He will have the staff resources to back him up. I'm very proud to say that Connecticut, having been on the negotiating committee that consummated this deal, we will be part of the monitoring committee. So state attorneys general from across the country, all 50 state attorneys general, will be assisting on the follow-up to ensure that the banks hit their numbers. But again, believe me, the banks it's in their interest to make these numbers, because the penalty for failure to make it is stiff.
So here in Connecticut, about 7,500 homeowners you think were improperly foreclosed on. And
Well, their foreclosure was proper in the sense that they were behind on their payments. The foreclosures were legal, but during the process by which they were foreclosed on, the banks broke the law.
And so they may be eligible for direct settlements of
Yes,
up to $2,500. Is that right?
It's going to depend on factors that I'll describe in 1 second. But my mother lost, when she was a child, she lost her home in foreclosure. They were wiped out by my mom's from Mississippi, which is where I was born. They were wiped out by the flood of 1927, and it affected my mom. She's 92 now, but it's something that kind of seared into her identity. It's something you never get over, and I just can't imagine the pain and suffering that people who have lost their homes in the last 5 or 6 years have gone through. And so there's nothing that I can do that's going to remove that, the horror and the pain of that. We felt, so even though these foreclosures were legal in the sense that the homeowners were behind on their payments, if they contested in court, they would have lost the home. The home would be foreclosed on. We felt that because they were mishandled by the banks during the process, that they ought to share to some degree possible in the settlement. And so I think it's about $4.5 billion has been allocated to make payments to those who lost their homes. Anybody who did lose their home can, and again, go to my website, and the contact information will be there. There'll be through the National Monitor, it'll be like a class action settlement where if you believe you qualify, there'll be a very simple form you'll be able to download and fill out. It's not available yet, but it will be soon. Fill out the form, which basically says I was foreclosed on during the 2008 to 2011 period. And you'll be able to qualify for a cash payment that we estimate will be between $1,500 and $2,000. It really depends on how many people from that, the class of people who were foreclosed on, participate in it. If we're estimating about 60% will participate, and if it's higher, then the amount of money to be shared, it's a fixed pot. So if participation rate is higher, the individual check will be a little bit less. If participation rates are lower, it'll be a little bit more.
But I think
rough justice, but it's
the more substantial piece, I think, is the potential for people to get a renegotiated mortgage.
Right. Our number one priority is keeping people in their homes, and we keep people in their homes. It means principal reductions and refinancing, and that's where the bulk of the money of the settlement will be directed.
And for that, people should be talking directly to their servicer.
Yes, the 1-800 numbers are available on my website.
Great. Well, it's a huge step forward. We'll obviously have to see how it works out. There's a lot of still moving pieces to go, and I think there's still going to be a lot of litigation around this going forward.
Yeah, there will be, and we've reserved our claims. Connecticut is the lead state on suing. I'm very proud to say is the lead state on suing the ratings agencies for labeling these mortgage-backed securities as AAA when they were junk.
Right.
We have not, and there's no release of criminal liability. My office doesn't have criminal jurisdiction, but if there are criminal cases that the feds or the state attorney's office can bring, those are still available. Most importantly, on the issue of securitization, which is the process by which these bad loans, these subprime loans, were loaded up by Wall Street banks essentially, and rated as AAA by the ratings agencies, and then sold to institutional investors.
Right.
Claims on the securitization that the Wall Street banks, for example, knew that they were junk and misrepresented them, those claims will go forward as well. So what the banks were released on really was the things that they paid for with the settlement.
Okay. Well, thank you, George, for talking about this and for all the work that you've done on this. It's, as I say, it's a big step forward, and I'd be interested to see how the lawsuits come out on the securitization side, because the mortgage ratings and all the bundling and the slicing and dicing, there's a lot still to be uncovered there.
There is a lot, and a lot of people did a great disservice to this country and the people of this country, and it's sad what people have been put through.
Oh, and then there are people who say greed is good. not what I believe.
Yeah.
Thanks for coming in.
It's my pleasure. Thanks for having me.
That's our show for this week. We hope you enjoyed it. If you'd like to learn more about progressive, grassroots political action, please check out our Democracy for America group. We meet the first Wednesday of the month at the Silver Star Diner in Norwalk, and we'd love to have you join us. Remember, change is possible, and you can make it happen. This has been Stream of Conscience, and I'm your host, John Hartwell. Thanks for watching.